Horrillo versus Cook. And good morning.
Good morning, Your Honors, and may it please the Court. I'm Thomas Burns, and this is Jeff Haberman. Together, we represent Mr. Horrillo. At closing argument, Cook said the number one most fundamental issue was medical causation, that is, whether the stent caused Ms. Horrillo's stroke. In fact, Cook essentially said that nothing else matters and spent over 10 pages of its closing argument addressing Dr. Gelblum's medical causation opinions and his credibility. That's why the evidence of the 4 strokes occurring during the post-2007 clinical trials and the warning label for the Formula 418 renal stent was so critical. Although neither piece of evidence showed notice to Cook, both went to medical causation. Both buttressed Dr. Gelblum's causation opinions, both impeached Cook's experts' causation opinions, and the label also demonstrated that a warning was feasible. The lack of that evidence led to an unfair trial on an unequal playing field, which substantially influenced the jury's verdict. And it was therefore an abuse of discretion for the district court to flip-flop and prohibit Mr. Horrillo from introducing that evidence at trial. Let's talk about the rebuttal issue first. When you're talking about the introduction of rebuttal evidence, there are really two paths that you go down. The first is your standard rebuttal evidence analysis, and the second is the doctrine of curative admissibility. The best place to start is with the omnibus order itself. And the omnibus order split the Rule 403 baby. It said that Cook can't present evidence that Ms. Horrillo was the only stroke, and it also said that Mr. Horrillo, in turn, can't present evidence about the 4 strokes during the post-2007 clinical trials. Now, Cook correctly points out that we had no issue with that ruling.
See, the problem I have with your argument is that was a post-incident clinical trial. What does that have to do with what everybody knew right before this surgery took place?
It doesn't. It doesn't have anything to do with notice.
Then why is it relevant?
It's relevant to causation meaning that there is a causal linkage between a stent put in the renal system and the occurrence of a stroke. Because during the post-2007 trial, as you know, they tried it on 100 people and 4 strokes occurred. So based on that evidence, the plaintiff's counsel could argue to the jury, look, there's a causal linkage here.
Right, but isn't the problem even with that the probative value as causative evidence was undermined because an independent review board had concluded that the 4 strokes that had occurred were not causally related to the implantation of the stents? Doesn't that undermine the argument?
You're correct to frame the problem the way that you're framing it, but that's an argument that goes to the weight of the evidence.
Well, I think it would go to the weight, but why wouldn't it go to admissibility as well? The judge, after all, is playing a gatekeeper role. He has to flash the light green and say, there's enough probative value here. The danger of confusion and unfair prejudice is small. I'm going to let it in. But he can conclude in his gatekeeper role, could he not, that it was post in some ways, to the extent it's going to the limited question of causation, its probative value was seriously limited, and the danger of confusion, misleading the jury, and taking you off on a different tangent was so great that in playing that gatekeeper role, he's going to keep it out. Now, what you've got to show me is not only was the trial judge wrong, but that determination amounted to an abuse of discretion. So even if I agreed with you and I were trying the case, I would have let it in. That's not the essential question. The essential question is whether you can establish that it was an abuse of discretion, which is a broader kind of area of review.
Of course, and like I said, I agree with the way that you're framing the problem. I'm just disagreeing with the conclusion that you seem tempted to draw. And there are a couple of things that I would point to.
I'm just asking the question of whether its causative value was not undermined by virtue of a determination by an independent review board, presumably of physicians, that this is not why the stroke happened. The cause was different. It wasn't because of implanting the stent.
I think I understand the question, so let me try and answer it. The first thing I'd point to is that this is a central issue, so it's going to the heart of the case, which I think would impact how you look at the probative value of the evidence. And then the second part is, although you have this evidence on one side where it's an independent FDA panel and they're saying no causal linkage, that's something that the plaintiff could impeach. They could say, well, the FDA is a captured industry, and they're saying what these medical device manufacturers want them to say, even though they're so-called independent, and therefore there can be some back and forth during the testimony where the plaintiff gets to cross-examine that evidence that would contradict the probative value, or as you suggest, of the post-2007 clinical trials. I don't think that would be confusing to the jury. The jury could hear both sides of that case and then decide, well, is this showing me a causal linkage or not? I mean, I think that's the kind of thing that.
But let me ask you the question this way: if the district court had followed down that course, wasn't there a substantial risk for the very reasons you've just suggested that the trial itself would have taken a detour into an area that was not directly and immediately at issue in the case, to it whether this independent review board's conclusion about 4 other arguably unrelated strokes were caused by this or not caused by that, and suddenly the jury would be led to have to try a collateral matter along with the essential matter.
It's a detour.
I'm just asking why the court couldn't think that this was more trouble than it was worth.
It's a detour, but it's a very small detour. And I think when you look at the one case that we cited, which is a 4th DCA wax, and then a series of cases that I cited in my Rule 28J letter, when something goes to the heart of an issue, a heart of the case, you really have to look at the evidence more closely. I think when you're doing the abuse of discretion review, you look at it with a closer eye. And so here, I don't think that the district court really had the discretion to exclude evidence that went to the heart of the case. Once we finish the standard rebuttal review, review of rebuttal evidence, you need to look at the doctrine of curative admissibility. And here, the doctrine is, well, if one side puts in an inadmissible evidence, and then the other side gets a chance to put in also inadmissible evidence. So there, you look at 3 things. What was the initial evidence inadmissible? The answer, I think, is yes, because the omnibus order said it was. The second question, is it proportional? And Wright and Miller has a very colorful way of explaining this, saying if one party throws a stink bomb into the jury, the other party can't throw a nuclear bomb into the jury. Here, I think that this evidence was a proportional response to the admission of this other evidence, and specifically that was the stuff about the impossibility defense, Rita Hardin's testimony that there were no strokes, and April Lavender's comment that there were no strokes reported when a biliary stent was used in renal vasculature up until October 17, 2009. And then the final thing is the Rule 403 analysis, which I think is the same for both. So either way, whether you look at your standard review or the curative admissibility, you need to look at Rule 403. Assuming I get past that, I have to demonstrate harmfulness. And there are a couple things I need to clear up that the briefs didn't really clear up. The first is that unlike a sufficiency of the evidence review, harmless error review doesn't require you to review the witness's credibility in the light most favorable to the victor. And as such, when credibility is in question, you ordinarily can't find harmlessness. And there are some factors that you look at, the number of errors, the closest of the factual disputes, the prejudicial effect, whether counsel, the jury instructions, and whether counsel intentionally elicited the evidence and focused on it. And so what I want to talk with you about here is this case was a battle of the experts. It's your classic plaintiff's case where you've got multiple doctors saying different things. And that's why this evidence was important. It was important to buttress our expert, impeach theirs, and go directly to causation. And then I want you to look at Cook's closing argument, which focuses on this stuff. They're saying, look, this is a medical causation case. The jury instructions didn't say to limit the testimony only to notice, the causation testimony, or the Hardin testimony and the April Lavender's testimony to notice. It could have done that. And then there's a question about whether it was intentional. I think the question to Ms. Hardin was probably not intentional, but the other stuff about medical causation and April Lavender's answer, that was intentional. So that's why we think there's harmfulness. Turning to the Rule 407 analysis on the label, this is a pretty interesting issue because I've never seen this kind of case where you have two different devices and the label for one is a warning for the other. Let's start with the omnibus order. The omnibus order excluded the label changes as a subsequent remedial measure under Rule 407, irrelevant under Rule 401, and also under the Rule 403 analysis. This is a misapplication of Rule 407. Rule 407 doesn't apply from the get-go because the label addressed causation, it addressed breach of warranty, it was not subsequent, and it was not remedial. The authority for subsequent remedial measures can go to causation is Brazos River Authority, which cites this court's opinion, it's an old Fifth Circuit opinion in 1972, which is Bailey against Kawasaki Kisen KK. And both of those say, look, if you're going to causation, Rule 407 doesn't apply from the beginning.
Even if you're right about that, why was it not still irrelevant, and why was it not more prejudicial than probative?
I think the relevance question is fairly straightforward. I think it's...
The reason I ask that is I understand that this label was attached years after your client had her surgery.
Yeah.
So why is it relevant, and why would it...
Right, and I think you're focusing on it sounds like you're focusing on the notice thing, and I concede it does not go to notice. I mean, we would need a time machine for this to be relevant to notice, and we don't have a time machine. It's relevant to causation, it's relevant to buttressing Dr. Gelblum's opinion, and it's relevant to impeaching Cook's experts. And it's important to realize that the label itself is something that's written by Cook and approved by the FDA. So the speaker is what makes this an important piece of evidence. This is Cook admitting that there's a causal linkage between using a stent in the renal system and stroke, period. It doesn't say, you know, stroke here, stroke there. It just says there's a causal linkage between renal application and stroke. So that's the relevance of it.
Do you have one case that says the remedial measure has to relate to the same product under Rule 407?
I don't, and I looked for that. We looked for a case where there were, you know, it's product A and then the label goes on product B. We couldn't find that. What we did find was the Brazos case, which talks about the causal linkage. But it seems to me that you couldn't have that. You couldn't have a remedial measure be about product B when you're really talking about product A because that doesn't remediate the danger that product A presented. It's just remediating the danger that product B presented.
Let me ask you this. Did you ever proffer this evidence to the judge for the purposes of impeaching? Did you ever say to the judge, I want to put this in because it goes to impeachment?
We did, and let me give you
tell me where in the record I can find
citations that I thought it did. Hold on. So at the end of the case, we say we want to proffer the deposition of Ted Heiss. That deposition is attached to Cook's motion in limine, which is document.
Right, but I want to know specifically where you may have said in words or substance, I need this stuff to impeach, to confront and rebut X, Y, and Z.
It's where we said that is day 15 of the trial when the defendant rests, and it's pages 210 through 212. And then the docket entries where I think the label was attached was document 183, Exhibit A, document 235-4, and document 394, where it's filed. And I wanted to point out, when we said that to the district judge at the close of the case, we said, look, we want to file this, we want to proffer this, and the judge says, yeah, I get what you're saying, go do that. So that's my understanding of where it is.
Okay, thank you.
You're
You're free. You've now eaten into your rebuttal. You're free to go on if you'd like or save.
Well, I didn't answer Judge Dubina's question about 403 if he wants me to. Otherwise, I can sit.
Sure. Why don't you take
Is that
the
okay?
time? Why don't you go answer the question?
Okay. So the Rule 403 analysis, I don't think the judge applied the right test. It said it's more unfairly prejudicial than probative, but that's not what the rule reads. The rule reads substantially outweighed by the danger of a litany of things. So I don't think it applied the right test. And I don't think there was unfair prejudice because for there to be unfair prejudice, it has to be likely to induce an emotional response on the part of the jury. That's Brazo's footnote 7. I don't think it was misleading or confusing because you could easily give a limiting instruction that says, jury, this evidence goes to causation. It does not go to notice. So they would understand what that evidence meant. And I don't think it was cumulative or wasting trial time because, like I said, the speakers were different. So this was a qualitatively different piece of evidence than any other piece of evidence that was put before the jury. And I kind of analogize it to like excluding a confession in a criminal case. This is Cook admitting that there is a causal linkage.
Thank you.
And then I don't think it's going to waste time because it's just the deposition of Ted Heiss and a document. So it's not a substantial piece.
Thank you, counsel.
Thank you.
And you have reserved 2 minutes for your rebuttal, Mr. Burns.
May it please the court, Dinah Stein, on behalf of the appellee, and with me today is Mr. Doug King, who tried the case for the defendant, Cook Medical, and the appellee contends that Judge Matthewman's rulings were correct before, during, and after trial. First, getting to the 4 strokes. First of all, the plaintiff doesn't take issue with the original ruling that the 4 strokes weren't going to come in, and this is the evidence that they say now is so crucial to their case that had to come into rebuttal. But I just wanted to direct the court specifically to the positions that the plaintiff took during trial regarding the 4 strokes, because I think it's extremely telling. It was the defendant who first raised the issue. He was very concerned with the evidence that the jury was hearing on the defendant's notice in 2007. The defendant wanted to modify a ruling regarding what evidence the jury could hear regarding notice in 2007. The defense was willing to open the door to this entire mini-trial just to get that evidence in, and the plaintiff resisted it and said, no, let's keep the original ruling. Judge Matthewman came up with an excellent solution during the trial, and this all took place on June 23rd when he turned to the plaintiff and he said at a sidebar, what if we allow this evidence of the defendant's knowledge, but we limit it to 2007, and we do not allow the defendant to say that there's never been a stroke reported? And the plaintiff said, you know, that's a good question. I think with that limitation, I have a very difficult prejudice argument. And if you look to, there's an entire dialogue starting around page 178 where the plaintiff makes it very clear. This is plaintiff's counsel. And he says it depends on how it's argued. There are 2 ways of arguing this. One is to say we were not on notice, which conflicts with the documents they filed with the FDA. Then that's okay. But if the argument is there have been no strokes associated with the use of the biliary stent in the renal artery, then you have opened the door to the 4 additional strokes. The defense represents at that discussion that they're not going to go beyond that limit, and the plaintiff essentially goes along with it, leading the court to believe that they were not going to take issue with the 4 strokes in rebuttal as long as the defense limited its argument. Judge Matthewman even said to the plaintiff, if something changes, if the door's opened, please bring it to my attention, we'll revisit it. The plaintiff didn't revisit it. 2 weeks went by, the plaintiff finished their case, the defense put on their case, the defense rests, and then the plaintiff says, I'd like to now bring the 4 strokes in as rebuttal. They've opened the door. Yes, they limited the testimony, but we think the door was open.
Let me ask the question this way. Accepting what you say that his justification switched, and he offered at least 3 different reasons for doing it, there does come a point where the argument is made, does there not, that it goes to causation. Tell me why this wouldn't go to causation.
Well,
not to notice, just to causation.
Correct, thank you. And so I think the plaintiff is a little bit overselling our causation defense because Cook never took the position that the the biliary stent used in the renal artery will never cause strokes. They couldn't take that position because we had stroke warnings that the jury heard on renal stents, and there was the letter that went to the cath directors. So that was not the argument. The argument about causation in this case was medical causation based on the specific procedure that was performed on the decedent, on Ms. Horrillo, and whether it happened based on not only the procedure but the medical records, because the defense brought in evidence, and I don't even think this was disagreed
No,
with.
I'm simply asking whether or not this went to the question of whether these other collateral four strokes were causally related to the implementation of the stents.
At the end of the day, no, there wasn't going to be relevance as to that causation because, as was pointed out and is from the record, an independent board originally determined that.
No, and I raised that with your colleague, but that was simply an argument. That does not necessarily answer the question of admissibility. It surely would go to weight. But why would it be such a powerful piece of evidence as to justify keeping it out altogether, as opposed to simply being able to argue one way or another about what an independent review board found?
The answer is it was an extremely weak piece of evidence that would have taken a tremendous amount of time to even address relevancy, and the jury, it was cumulative.
Right, so the essence of your argument has to be whatever probative value it had, and that was slender, it was demonstrably outweighed by the danger and risk of moving the trial into a wholly collateral issue.
That is the essence of the argument, that any probative value was going to be
Well, but
far outweighed.
wouldn't you have to concede that it has some probative value
No,
on the issue of causation?
Absolutely not. I would not concede that. The plaintiff didn't even take that position at trial. The reason being, first of all, this happened.
Let me stop you at that point. Did he never say to the trial judge, the value here goes to causation?
I don't think that was argued
Never made
as
that argument.
affirmatively as it's being argued now. That the causation defense really, again, Cook wasn't saying these stents can't cause stroke. It was saying it didn't cause stroke in this case. So what the plaintiff said at trial was, I agree that if the defense's evidence is limited, it's not going to be relevant because we're only talking about notice now. And that if the defense had said there was never a stroke reported with the stent, then it would have been relevant. Well, the defense never brought in evidence that there was never a stroke reported.
What about Mrs. Harden's testimony?
If that is read in context, first of all, there was no contemporaneous objection to it. If it's read in context, she was clearly responding to a question asking about whether something had been reported as of May 31st, 2007. And that's, I would say,
But she
extremely.
specifically said there were no strokes.
Well, this is what she was responding to. Do you recall ever reporting to executive management, such as Mr. Roberts, Ms. Lavender, and so forth, prior to May 31st, 2007, that there had been any strokes or other serious injuries reported, etc.? She answers no. Why is that? Because there were no strokes. I think the context was clear, and if it wasn't, there would have been a contemporaneous objection. And in fact, when the plaintiff, at the end of the defense case, moved to reopen the door, that wasn't argued. The plaintiff didn't say this changed everything. He just said,
But your argument is that really went just to notice and not causation.
absolutely. That's absolutely the argument, is that the defense had a right to show. The plaintiff had brought in a lot of evidence that the FDA was concerned about off-label use of biliary stents, and that there was a strong implication that this involved the Cook stent. And the court agreed with the defense that the defense had a right to come back and talk about specifically what their notice was at the time of this injury, so it can defend itself on whether it was obligated or what it was obligated to do at the relevant times. So that was the relevance of that evidence, and the defense never departed from the spirit of that ruling. And never said that there was never any reported strokes in regard to this stent. So again, and the other thing is, and this applies as well to the labeling argument, the jury heard evidence that the renal stent that Cook used in Europe had a risk of stroke in the instructions for use. It heard argument and evidence that when the defendant applied to the FDA for pre-IDE being able to test the renal stent, that it reported a potential risk of stroke. It heard evidence that the cath lab directors were told by Cook that off-label use of the biliary stent had a risk of stroke. So what this 4 incidences that happened 2 years after the incident is, it has absolutely no added value to this case and was going to cause an entire collateral mini trial on this issue, which was now brought to the attention after the defense rested. So a lot of things would have had to be reopened. So I go back to the fact that Judge Matthewman really bent over backwards to deal with this ruling, did everything he could to make it fair to both sides, and was well within his discretion in not allowing this rebuttal that the plaintiff didn't even care so much about at the beginning, the start of the trial. And that goes to labeling as well. And I think, unless your honors have questions about the 4 strokes, I do want to briefly address the labeling. The court made an in limine ruling regarding the label, and the plaintiff essentially let it die on the vine, never once brought it to the attention of the court during trial. The proffer that plaintiff was referring to, I believe, was proffer of the 4 strokes evidence and not the label. And that was Judge Matthewman's frustration in his order, which I think reads through it, in that I made a ruling at that time. You never proffered this to me at trial. I don't even know the relevance as of now. And I think significantly, if you go back to the discussions that were had with the 4 strokes, it shows that Judge Matthewman was extremely willing to revisit his in limine rulings. He even said on occasion, I make these rulings in a vacuum. If you think something's changed, please bring it to my attention. And I believe the reason plaintiff didn't bring it to the court's attention is because they already had the evidence in, again, the European label, which was exactly the same, the pre-IDA application that the defendant submitted to the FDA, et cetera. So it was not critical evidence, and it was never brought to the attention of the court. And unless your honors have specific questions on the other 2 arguments regarding great weight of the evidence.
Why don't you go to the merits of that? Let's just assume, for the purposes of my question, that he did preserve it. Let's go to the argument, the merits of that argument about the labeling.
As far as, I mean, it is a different product, which I think makes it even, questions the relevancy even more. This is a label that was done 2 years after, I believe, at least 2 years, in fact more, after the incident. It deals with the renal stent, and the jury already had overwhelming evidence of labeling of Cook's renal stent, to the extent that plaintiff specifically discussed it in closing argument, told the jury, you've seen this evidence of the labeling of Cook's renal stent. So I'm saying a little bit of merits and a little bit of whether this was needed, but the jury already had that information. So on the merits, I'm not sure what probative value it added to anything in the trial, and I think that would explain why it wasn't raised as an issue during the 4 weeks of trial by the plaintiff, who never proffered it a single time. So I think that's the answer to that. If your honors have additional.
No, thank you.
Thank you, your honors. Thank you for the time, and we'll rest on the briefs for the remaining points. Thank you.
Thank you, counsel. Mr. Burns, you have 2 minutes.
The first thing I want to address is whether the causation argument was preserved. It's my understanding it was preserved on day 15, pages 210 to 212, when we're talking about why the label needs, or why we need rebuttal testimony. If you disagree, we can file something supplemental to say this is where in the record that is. But it's our understanding it was preserved. The last thing that my colleague was talking about was, well, these are different products, so anything about labeling one is irrelevant to the other. Just so you understand, it's the same physical device. It just goes in box A or box B. That's why it's relevant, because the warnings are different. But it's the same physical thing. My colleague also said that this evidence was cumulative, but it was cumulative of the European label and the informed consent forms. But they said something very different in their answer brief at pages 29 to 30. They said the warnings accompanying the European renal stent and listed on the consent form for the American renal clinical trials were broadly worded so as to cover risks associated with all possible methods of performing renal stenting surgery, including where access is accomplished through carotid artery, as some physicians prefer. So that's a different position that they're taking now. And these pieces of evidence are really quite different. They're different speakers, and they're different things, because one is approved by the FDA and the other is approved by these other regulatory authorities. And they're worded broadly in those other things, but more narrowly in the piece of evidence that we wanted. There was a point about we agreed with the omnibus order. But the reason we agreed with it is because the district court repeatedly said, if they do this, it's going to open the door. And then that's what happened at trial. They did that, and it opened the door, and then we wanted to present that evidence, and we were denied that ability. So that's why this is what we think is an unfair trial. They got to fight with both arms, and we got to fight with only one.
Thank you, counsel. Thank you both. This court will be in recess for about 15 minutes.